All rise. Hear ye, hear ye. The Court of Appeals in the state of Kansas is now in session. The Honorable Ellis presiding.
Good afternoon, you may be seated. Good afternoon. This is the afternoon docket of the May 10th, 2022 session of the Kansas Court of Appeals. My name is Amy Klein, and the Chief Judge has appointed me as the presiding judge for today's proceedings. Joining me, I have Judge Leslie Isherwood and Judge J.C. Hurst. My pleasure and privilege to serve with both of them. As I mentioned this morning, this is our first in-person argument since we become judges, and so we're very excited to see all of you here in the courtroom. And so if you're a little rusty arguing in person, let me tell you, I am too. I won't speak for them, but I will tell you that I'm a little rusty too. The first matter we have on the docket this afternoon is case number 124-169, Alex Fisher versus Kansas Department of Revenue. I'll have you enter your appearances in a moment. I do want to make sure to let you know that if you need time for rebuttal, to tell me so I can keep track of that. And remind counsel that we've read the briefs and we've also had a memorandum prepared for us by very talented research attorneys. So we're pretty familiar with the facts. If you want to delve right in, we would appreciate it. So if you want to go ahead and enter your appearances, we'll get those marked down and get started.
Mr. Fisher, the appellant appears by counsel Tom Bass.
One that appears by me, not respondent, sorry, the appellate.
Thank you. All right, you may proceed.
Can we sit the tables?
Yes, please do. I'll also mention, before you get started, we are streaming on YouTube. And so if you could give just a brief description of the case, it won't count against your time, but it will kind of orient people. If somebody's watching on YouTube, it'll kind of tell them a little bit about why we are here today, just, a minute or so, and I won't count it into your time.
Certainly. May it please the court, counsel. Mr. Fisher is here on an appeal regarding what we claim is a deficiency in what is called a DC-27. DC-27 is a document that's given to a citizen when they receive a DUI and the police officer believes someone has failed or refused usually a breath test, but can be a breath test, urine or blood. In this case, the DC-27 given to Mr. Fisher did not have the date correct on paragraph 1 or paragraph 8 of the form. It's a pre-printed form that's given out by the Kansas Department of Revenue and used by law enforcement officers. In this case, the date given to Mr. Fisher was April 25th of 2019, when the date should have been August 25th of 2019. Mr. Fisher is here asking me to ask the court for some clarity as to whether the word shall means must, means maybe, or means never.
And before we get into your argument, it sounds like maybe you're heading there a little bit. I did want to make sure, did you want some time for rebuttal?
1 minute.
Okay, well, all right, then maybe I was jumping the gun there. No problem, you may proceed.
Thank you. As I said, Mr. Fisher is looking for some direction as to whether 8-1002, when it says shall, what does that mean? And this, I think, is a case of first impression as it relates to what I'm going to call paragraph 8. There have been a number of cases over the years that have interpreted different paragraphs. Some of those cases address paragraph 8, but in particular, paragraph 8 has not been addressed. The courts are probably aware of the fact that the legislature some time ago set up a statutory scheme that essentially took away what one might call a lot of our citizens' rights as it relates to Department of Revenue license hearings. That's fair, they get to do that. But in exchange for doing that, the legislature laid out a very clear path to law enforcement, to the Department of Revenue, that if you're going to take somebody's driver's license, this is what you need to do. And it's really fairly straightforward. You might ask then, why are we here 3 years later arguing for the Court of Appeals on what appears to be, according to Bath, a fairly simple argument? Well, I would say some of the cases we've had over the last years have not been as clear as they could have been. And that's really one of the reasons for clarity. Mr. Fisher wants it for his case. Those of us in the trenches want the clarity so that we know whether to bring these issues up to the district court and litigate them. But I think it's important for the court to know that most citizens only contact with law enforcement in their lives in Kansas, the greatest percentage is DUIs. I mean, we all know that. And the point is that's important to those people. And it's important that they be able to drive, that we don't have public transportation if you're in Oberlin or if you're in Pittsburgh or wherever you might be. And we respect the process and that someone can lose their driver's license, but we also respect that the process should be followed. And so Mr. Fisher sits across from me and doesn't understand why are we at the Court of Appeals? It says shall, and it wasn't done. And that brings us back to where the issue that's before us. And I also should say this, there's been some discussion like in the Sandate decision and some of the other decisions like, well, these can be raised the first time the KDOR sees this when you request a hearing, or can be raised at the administrative hearing. And I would like to disabuse the court of the notion that there's a lot being done at either of those levels. And having practiced for 35 years in this area, I'm fairly familiar with how this happens. And that is, sure, if something's not correct at the first hearing level, they may dismiss the suspension if one of these isn't initialed or marked. Those are pretty easy. But when there's a wrong date, KDOR in Topeka doesn't know that. The administrative hearing officer is not really much more of a check the box too. I mean, if you show up and we raised this argument, it was rejected. And so I don't want this court to think, well, there's a very efficient system in place for some of these arguments, because clearly we're here on this case. And certainly our firm took this case because we think it's important to get it clarified. The statutory scheme 8-1002 has a number of subsections. The statute itself says shall at least 8 times by my count, but sections 1 deal with a refusal, section 2 and 3 a test failure, and then D, what we're here for about today, relates back to both 1, 2, and 3. In other words, they didn't repeat D for 1, 2, and 3. They just said, in addition to subsection A, which encompasses 1, 2, and 3, here's the things you need to do. And I know this court's familiar with the briefing, and I won't go over our entire brief again, but Schmidt was the first case in 2010 that addressed some of these issues. But that was a wrong date in paragraph 1. And essentially Schmidt said the statute doesn't require that. And the Department of Revenue is banging that drum for years, right? If the statute doesn't require it, then we don't need to do it. But then when the statute does require it, like here, oh, well, you still don't need to do it. I don't think that's a fair interpretation. And the substantial compliance argument comes really out of 8-1001 does not bleed over, I would argue, to 1002, or should not bleed over to 1002, especially when there's clear legislative mandates. Then we had Felgate. Felgate was a wrong date on paragraph 1. It affirmed Schmidt. That was 2011. Pratt, there was a failure to check the box regarding the manner of service, and it said 8-1001 only requires date of service, not manner of service. Okay, those are all fair interpretations. What the statute tells us doesn't tell us. The dicta in Pratt, however, said subsection D requires date of notice being served. That's dicta, but it's there. Wall was a certified failure when it was really a refusal. And essentially, they said that violates 8-1002A, meaning they strictly interpreted, Wall did, the statute. Stutzman was missing initials, check marks, signatures. It violated A and D. And it said in dicta, information that must be included is the date of service. That's on page 3 of that Stutzman opinion. Then we get to Sandate. And I'm familiar with Sandate. Sandate was my case. And Sandate really was a case that arrived 1617 when we had the law requires you to take a test. And then the Department of Revenue essentially changed the implied consent advisory to comply with the law, but the law didn't change. It did in the court, but it didn't in the statute. And we raised those issues, and it was, I would argue, an 8-1001 case. I recognize that Sandate then started talking about jurisdiction. I would argue to you, it went a little far afield, and it really is an 8-1001 case, not a 1002 case. And the dicta from Sandate, I apologize, if the S case is confused. Sandate, however, talked about the DC 27 being contested at the administrative hearing. Of course, I would argue that assumes a deficiency is one that can be challenged, because there are narrow grounds on which a citizen can challenge the DC 27 on appeal. And I would argue to you, if Sandate is good law, then notwithstanding the fact that D says the date shall be included, that the citizen would not be allowed to address that on appeal. I also want to point out, and then we had Vance, which is the most recent case. And Vance really was a case that involved non-statutory violations. And it seemed to adopt, and does adopt in some sense, the Sandate language. But I would direct
Like a full-throated adoption to me. I mean, that's what I've got in front of me. And I'm glad you're talking about that, because that's the question that I have, is the jurisdiction question, because Sandate, Vance, and I think Trowbridge is another one where it seems like the modern trend on our court is to say that if you're going to ask us whether the form was correctly filled out, we have to have jurisdiction in order to answer that question, right? Doesn't the
That's correct.
statute give us the authority to look at the form?
I think, well, it's the only way we can argue is jurisdiction. We don't, how else can the citizen under the statutory scheme can't argue the date being wrong else other than jurisdiction. So we're sort of forced that way. Now, this court could say, well, yeah, I know it says the date and we agree with you, it should be included, but because you're restricted by what you can appeal, that doesn't count. We don't term that to be jurisdictional, and Bath, you lose.
Well, but the case law also talks about you can raise these procedural type issues, and this is a procedural issue. You didn't follow the procedures on the form, and that you're not prevented from raising this procedural type of issue in an administrative hearing.
I don't disagree with that, but I mean, it's a difference between the statute 1000 D says it shall, and then whether that constitutes jurisdiction. We raised it with the administrative hearing judge. We raised it with Judge Vano, and I argue that I think it still falls within that. But I could see a path where I lose that, where you say, well, I know that says that, but the legislature doesn't give you the right to raise it. That jurisdiction really means something different than 1002 D. I would disagree with that, but I understand that. And if that's where you're ruling, that helps clear, I think, give some clarity to all of us on how we're moving forward. But
because that's the issue I have. It seems like a chicken and egg kind of a situation. If I have to look at the form to see if the form's complied, or if the form is properly filled out, then I would seem to have jurisdiction under the statute to do that. And isn't it the statute that gives me jurisdiction and not the form? Because that's what Sandate is saying, that just because the form is not properly filled out, that doesn't mean, okay, now I have no jurisdiction, but I had to exercise it in order to look at the form itself.
And you're right. I mean, it's a chicken and egg. I guess my question is, well, are we saying then that when it says shall in there, that's just, that there is no recourse for a citizen at all? I think
No, that's my question is, couldn't they, under the other cases that you all talk about with respect to this is a procedural issue, you're raising that you can certainly raise a procedural issue below. I don't know why you couldn't say, look, the statute wasn't complied with in your administrative hearing.
Yes, I think however we get there, and we're sort of being told, Sandate tells us sort of a different way you're supposed to maybe bring that up. I think it's a lot of substance. I mean, a lot of form over substance in terms of how we get to whether Mr. Fisher gets relief. Does that make sense?
It does. And that's what I want to talk about is, why do you think that Sandate precludes him from raising this issue at the administrative level like you did below?
Well, I'm not sure Sandate, I think Sandate could be, depends if you sort of read it with like the criminal complaint gets things rolling, the comparison there. But then Judge Arneberger says, but you can challenge that essentially in the district court on a criminal. I think that opinion went too far in trying to make that comparison. I think if you go back to the Wall-Stutzman analysis, I think that's the cleaner way. And I disagree that there is any jurisdictional bar, or there's any bar from us raising this issue. If I can move to Vance very quickly, and that Vance was not a statutory violation, but it did say in two different places there, page 2 and page 5. Page 2 says, it goes through the paragraphs. It's sort of interesting on Vance. They're like, here's what is required each of these paragraphs. And it says paragraph 8 requires the date. And then later on page 5, they certainly seem to imply that if there were statutory problems, it would render the certification meaningless. So even though Vance seems to support Sandate, I think it does in some respects, as it relates to this argument, I think it supports our argument as well.
I mean, on the merits.
Yes, on the merits, on the fact that it says shall. I don't know if I've used up all my time or if you have questions, but that's,
It's about 3.5 minutes left.
that's all I have. Thank you.
Any other questions? Thank you. I really appreciate it. And we appreciate the concise nature of your briefing as well.
May it please the court.
Certainly.
I just want to go over the DC 27 form. Since this issue is focusing just on that form in one of the paragraphs. It was developed by the Kansas Department of Revenue to aid the law enforcement officers, the Department of Motor Vehicles, and the drivers that are requested to submit to testing. There are two main components, a notification aspect and a certification aspect. The notification aspect arises from KSA 8-1001, and the certification focuses on KSA 8-1002, where this argument is coming from. Here, I would say that the statute does give jurisdiction to review the DC 27. If, as you had stated earlier, Judge, if we're not able to look at the document, then we wouldn't be able to get jurisdiction. But because we're able to review the document itself, and this was a completed document, even though one of the DC 27s in this case was incorrect, it was corrected later on. And so the Department of Revenue would state that even if it wasn't corrected, we would still have jurisdiction to at least review the document itself. And I will bring up Sand-Aid as well, because it is important in this case that, and I'm just going to read from the actual decision, that the Department of Revenue and the courts have to have jurisdiction to make the decision regarding the adequacy of the DC 27. And they also state that even if Department of Revenue should have dismissed it upon filing and should have never required the licensee to request an administrative hearing, that can only be determined if an administrative or judicial officer's decision can determine that. And so an error in the Kansas Department of Revenue's decision doesn't impact the jurisdiction that we have to make that decision. And the courts and the Department of Revenue are not somehow deprived of that jurisdiction just because something in the DC 27 could be found as insufficient. There's also case law, and I will also bring up Felgate, that states that minor mistakes, such as having a wrong date, doesn't conflict or would conflict if we were to allow the minor mistake to not grant us jurisdiction to review the document. It wouldn't be the legislative intent, which is to remove drunk drivers from the Kansas roads. And so in Felgate, and this is a quote from it, when a law enforcement officer fills out the notice informing a driver he or she has failed a breath test, time or at least the correct date of the incident is not of the essence. And so we would state that also we would like for the court to notice that these implied consent laws are KSA 8-1001, and that entire section plus the KJRA 77-601 and KSA 8-259 that gives us the jurisdiction in order to review these cases. And especially KSA 8-1001 subsection U states that this act is a remedial law and shall be construed to promote public health, safety, and welfare. If we were to allow a simple date on it be incorrect on a DC 27, the Department of Revenue doesn't think that that would be the legislative intent.
Well, counsel, I mean, the difference between this case and Felgate is this case involves a statutory requirement to include the date, correct?
Yes.
And it could be, I mean, we don't appear to have a problem in this case, but I could see a situation where an incorrect date could prejudice somebody in terms of their notice, because particularly this date gives somebody the deadline in order to request a hearing and tells them how long that their temporary license is going to be in effect, correct?
Yes,
because it goes from the date of notice. And so an incorrect date there could cause somebody to get into some trouble. They may miss their deadline to file for a hearing, or they may get, you know, a ticket for driving on a suspended license because they thought maybe their license was still valid.
yes. And that would bring me to the point where, in this case, there has been no prejudice shown. In other cases such as Batliner, it states that if no actual prejudice is shown from the licensee, then there's no reason for the Department of Revenue to lose jurisdiction over the matter itself.
Council, can I ask a
Yes.
quick question? You spoke earlier about the original DC 27, and then you said there was a corrected one.
Yes,
Can you tell us the mechanism for that correction?
so neither party is sure exactly when the DC 27 was corrected. However, from the exhibit itself, it's in the agency record if you need a.
Oh, no,
You've seen it,
I've
okay.
seen it. I'm inquiring about
Oh.
how the correction came about, under what provisions is the KDOR permitted to make that correction?
So we're,
And how was that sort of notice given to Mr. Fisher regarding that correction?
so we're unsure if the officer was the one to correct it. It's not, it's, in my understanding, it's not the KDOR that would fix that type of mistake. It does state on that particular page that it was received by us. However, the handwritten correction, we are unsure who did that and whether or not it was received. Although I would state that the DC 27s automatically come in under statute if they are certified by the officer. And so both DC 27s in this case would be into evidence even if it was not put into evidence at trial. And if you need that statute, I can, okay.
No. I'm just inquiring about sort of the mechanism by which this would be done. I mean, are you aware that a lot of these are corrected at the time? Because these do come to us with errors on appeal. And it doesn't seem that there's a real process for the correction of those prior to that.
I believe that when we open up when we receive the DC 27s at the Department of Revenue, we have a staff review and set a date for a hearing if the hearing is requested. And so we don't look at the DC 27 and try to make sure everything is correct and factual findings or anything like that. And again, that would come back to, we have jurisdiction to review those DC 27s in order to set up an administrative hearing if it was requested by the licensee. And also the memorandum decision in this matter, the judge states that the defects in the original certified document that was corrected in the agency record and in parentheses by someone did not deprive either the agency or the district court of subject matter jurisdiction to address this case. And they also made a finding that it was clear that the appellant was not prejudiced by the error or by the correction itself. And so we would state that even if this is a minor detail in a DC 27 in this case, that it did not deprive anybody of any due process. It did not prejudice the appellant in this case, and that the court should find that the order should stand. No more.
Okay, any other questions? Thank you. I know you said you only wanted a minute, but you do have 2.5, so I'll give them to you. You don't have to use them all,
Well,
but you're able to. How about that?
I might. So just Judge Hurst.
Of course you will. You're an attorney.
Yes, brings up an interesting question, and I wrote down when KDR said, well, it was corrected later on. This happens. It happens with some frequency. I would call it monkeying around with a record. In other words, somehow somebody in KDOR figures out there's a problem, and understand that that agency record, it could be a year before that's submitted to the district court, right? You have the hearing, then you have a petition for appeal, maybe not a year, but it could be 8 or 9 months before they have to do their answer. And it seems to me it's improper for anybody to change any kind of document that was originally served on a citizen and not make some memorandum of it and it be in the agency record. I think that's a sort of a red herring. I understand why you're interested, but we've run into that before. And it seems to me that that shouldn't happen ever, or at least there should be notification to council. Hey, somebody is changing an official document that's going to be part of the record, but instead they change it and then they just dump the agency record in for appeal and then want to try to argue, well, what's the harm? Which now relates me to what's the prejudice? What's the measure going to be? If you come out with this opinion and say, well, you've got to show some prejudice, what's the prejudice, meter? And is that what we're going to turn district courts into now? I don't even know I was supposed to show that at the district court. In other words, I don't think I was put on notice that I had to show there was prejudice. And I think we're getting into an area where we don't need to get, because the legislature, the people have spoken and they said the date shall be in there. And I understand Department of Revenue, and she's arguing her position. She needs to do that. But I don't think we start turning district court trials into prejudice trials. And frankly, Alex was just lucky he got a lawyer. What about the people, the guy in Pratt or the gal in Overland, right, who doesn't even know any difference and reads that? And that form has a lot, right? It's a front and back. There's a lot of information there. And essentially it tells them that you're suspended 30 days from that date. And if they don't make the request of the hearing. And so in this case, when it said April, anybody who doesn't get a lawyer says, well, I got suspended starting April of that date. Now, then triggers the restriction. And if they think they've already been suspended, then they don't do a request for a hearing. You would never know. We'll never know those cases, right? We never hear about those kind of people. It's not going to be as big a deal because July 1, you can have an ignition interlock device. But let me hearken you back to 06 to 12, when it was a 1-year suspension. You couldn't modify it at all. You couldn't expunge DUIs. Remember, we've gone through lots of variations over the years. My point is, I think that's a rabbit hole that's not appropriate on the prejudice. I think the fact of the matter is the legislature has taken away rights from citizens. That's fair. They've told law enforcement what they need to do. It's a fairly easy process. It's not really very confusing. And if you start saying, well, that date didn't really matter because he wasn't prejudiced, doesn't that encourage law enforcement not to follow the forms because they know the fallback's going to be, well, there's no prejudice? I just think my argument is this is a fairly easy decision here. And I think the date has to be there. That's what the statute tells us. And that's what has to happen.
And to be clear, you're only raising the jurisdictional issue. You haven't addressed the merits and the prejudice issue. I mean, that's what you're telling us now. And that's how I read your brief is you're simply saying we have no jurisdiction.
That's correct.
Okay.
Yes, that's correct. Thank you so much.
Thank you. Thank you both. We appreciate your briefs and your arguments today. We'll take this matter under advisement and we'll get out a decision as soon as possible.
Thank you.
We'll go ahead and move on to our second case on the afternoon docket today, case number 124-347, Aubrey Illig versus Renee Ballou in the Kansas City Women's Clinic. And counsel, feel free to come up and then we'll go ahead and get your appearances on the record. Well, you are. We just only have 2 today.
Okay.
One of the cases disappeared.
Yeah, we had some more this morning. That's okay.
Okay.
Yeah, whenever you're ready, we'll go ahead and get your name for the record.
Sure. Your Honors, it's a pleasure to be here today. My name is Michelle Illig, and I am representing the appellant, Aubrey Illig.
Good afternoon, Your Honors. I am Adam Davis with Mike Stephan Carmel. I'm here representing all defendants. I will also mention that with me Diana Beckman, who handled much of the case, and Karen Fritz, who's a first-year associate at our law firm, recent KU grad. So
Welcome.
you're observing for when she's doing the argument.
Great.
Thank you.
No problem. Counsel, you may approach, and I think your microphone may be just up here at the podium. And so we'll get the rest of what we have to talk about procedurally when you are ready to go ahead and get up there. We're still getting used to all the new courtroom technology.
Well, and I am experiencing a first with you because it's my first time to ever be here in the Kansas Appellate Court.
Welcome.
So I wish it were for other reasons, but it's kind of exciting if I separate them. So
It is. Now, counsel, each side has been granted 15 minutes of oral argument
Yes.
today. And do you know how much time you'd like to reserve for rebuttal?
I would like to reserve 5.
Okay, you absolutely can do that. And then whenever you're ready, you can go ahead and proceed.
Okay. Do you want me to give just a very high level back summary? Because
Yeah, sure. And I'll like I offered the morning, if you want to give that high level summary, I won't start your time, just maybe a minute or two, kind of
Okay.
explaining why we're here.
Okay, very well. This is a case that's based on medical malpractice and negligence. The appellant in this case was subjected to 6 shots of Gardasil, and the most that's ever recommended by the CDC is 3. Shots 1, 2, and 3 were seen in the vaccine injury court, and shots 4, 5, and 6 is what's before the district court and now you all for medical malpractice and negligence. The reason that we're here, I'm trying to make it very high level for the viewers, is because the district court granted the motion for summary judgment that was issued by defendants based on their belief that this case is so complex that it requires medical expert testimony. And our position is, if there's ever been a case in medical malpractice and negligence that's very clear and very easy for any of us to understand, it's this case. I mean, this is the type of case that the common knowledge exception was written for. But the district court judge did not see it my way, saw it the way of the defendants. And for various reasons, I feel like it was an error. And here we are today. I do.
Go ahead and start your time.
I do want to share, if it's okay, so that maybe it helps the viewers. This is not my area of law. Never done medical malpractice. As a matter of fact, getting my law degree was my second thing I did in my life. My first degree was as a CPA. I haven't practiced law with a big firm. Anything I've ever done has been as a solo practitioner. But I know what happened to my client, who is my daughter. I know what happened was gross negligence, and I don't file frivolous lawsuits. And I just want to share that. So bear with me. I think my substance is solid. Sometimes my form's off. And the more I've done this, and the more I've read, and the more I've researched, the more I've realized it going, oh, if I could go write that again, or if I could go write that again. But I do believe that my case is solid, and I'll look forward to your opinion. Okay.
Thank you.
I think I'm just going to start with the fact that, like I said, this was inappropriate for multiple reasons. There were material facts in dispute at the time. And one of the claims of the defense is that there was no clear standard of care. And to make sure, you all probably know this, but for the viewers, our case really was filed over 3 years ago. And we were in front of a different judge, and he retired. But he was with us for about a year and had even set us for trial, and then the pandemic hit. Everything was put on hold, and my daughter is probably pretty susceptible now. She was extremely healthy before all this happened. I'm going to try not to get emotional.
Understand.
Sorry.
It's okay.
It's why they say don't. It's why they say that don't have a family member do it. I'm okay. So anyway,
Counsel, we're all moms. We're all moms up here. We understand.
thank you. So where was I? So the mere fact that we were in front of the district court, to me, reflected the fact that it was a breach in the standard of care. And the reason I say that is I don't know how familiar everybody is with the National Vaccine Injury Act. That was put in place in 1986. And the reason that was put in place is because there was risk with vaccines. And the vaccine manufacturers convinced the legislation at the federal level that they shouldn't be held liable for somebody who's predisposed and it's a safe vaccine, but they have an adverse reaction. So the National Vaccine Injury Court started. And anytime a provider follows the schedule, anytime they follow what the CDC tells them to do, that's where they have to go. That's where all the vaccine injuries are heard. But the courts don't protect malpractice. The courts don't, the National Vaccine Injury Court, it doesn't protect doctors who don't follow the schedule, because that wouldn't make sense, right? That wouldn't make sense for the manufacturers. That wouldn't make sense for public policy. And so if it were just shots 1, 2, and 3, we wouldn't be here. But the fact, and the National Vaccine Injury Court is well aware of what we're doing. They agree that 4, 5, and 6 do not have to be seen in front of them. And we think there's no amount of money that could ever compensate us. None, nothing. But my daughter, she wants the doctor and the clinic to be held accountable. And they lost her vaccine records. And the reason we found out is because she was extremely healthy and something was happening to her and it made no sense. And so I called the clinic up in 2018 and I said, I need the records. I need to see what happened. And we didn't know. And that's where we discovered it. And I found out they lost them in a system migration. That's how it happened. My daughter was given the 3 Gardasil vaccines in 2014. In 2015, they did a system migration. When my daughter went back for her annual PAP in 2016, the Dr. Ballou said, "You've never had Gardasil." My daughter said, "Yeah, I have." And she said, "No, you haven't." And I've got record after record that says no Gardasil, no Gardasil, no Gardasil.
Ms. Edling, I want to clarify something that was a little bit unclear from
Sure.
the record when I reviewed it. Did your daughter have all 3 of the first round at KCWC, or did she just have 1 there?
In January of 2014, Dr. Ballou wrote the order and she had her first one with her and the order followed her to K-State.
Okay.
Dr. Ballou's order went with her. And so she had 2 and 3 at, at K-State.
Okay, so the 2nd and 3rd vaccines were with a different clinic.
Right.
Okay.
But they were under her order.
Okay.
She ordered all 3 and she knew she was away at college at the time.
Okay.
Does that answer your
Yes, it
question?
does. Thank you
Okay.
so much.
Is there an indication that that Dr. Ballou then received notification that those 2nd and 3rd shots were administered?
I would assume so. The challenge that we have, Your Honor, is all the vaccine records were dropped in the system migration. There's nothing out there.
Do you recall requesting those records from college to be sent to KCWC?
Do I personally recall that? No.
I think we understand the facts of this case and what you're alleging. And we appreciate how you feel. More than you might understand. I don't want to get choked up. My kid's health is more important to me than anything in the world. One of the issues that we struggle with in this case, so let's assume that you're correct in that the standard of care could be common knowledge. Case law is not great for you on that, but let's,
I'm sorry,
the
say that
case
again.
law is not terrific for you on that, but let's assume it. We have to move on then to the causation issue. And let's say we accept as fact that your daughter received twice the doses that she should. What did you propose to bring to the court to demonstrate that the extra 3 vaccines caused her health issue?
Excellent question. I thought you guys would ask that. There's a case through the Secretary of Health and Human Services. It's Morgan v. Secretary, HHS. And in that case, that was a case that was in vaccine injury court, but the reason it's relevant here is this. It's an off-the-table injury, and it's an off-the-table injury if vaccine injury court is supposed to be a lot simpler than it is. It's really quite cumbersome, and in the end, you often have to prove causation. And in this case, that's what happened. The doctor still had to prove causation, and it was from a 3 shots of Gardasil, a gal developed ulcerative colitis. The reason I give you that backstory is because what happened there was it was her doctor who followed her, who knew her case, who was able to testify to what he observed. And it is, I try to be logical because I realize even if I may not always know the law, usually the law is ultimately logical. It may get convoluted along the way and somebody may take it and misinterpret it, or they, no offense to you guys, but they try to protect the insurance companies and things get misconstrued. And the reason I go there is because if I always think about my audience, right? And if I'm on the jury, I'm going to find a lot more credibility in a doctor who was with her, who witnessed it, who saw what happened versus paid experts, because they're just going to wash each other out. So how would I get it in? I guess I would get it in that way because it was allowed in that court because they knew that doctor actually brought so much more information, because what's the goal with a medical expert?
Did you submit that physician's name to the court as your expert for causation?
No, and I'll tell you why. Well, I mean, I brought it up, but I did not present it because he was going to be one of the witnesses. I mean, he was going to be there as a lay witness, or one of her doctors testifying anyway. And so why would it not be acceptable for him to testify as to what he observed and what his knowledge is? I mean, he would be more knowledgeable of that than me bringing in another OBGYN who would say, yeah, that she did breach the standard of care, because any doctor would say that.
Okay, so you intended to use her personal physician?
Her gastroenterologist, the one who she saw for the first time because of the ulcerative colitis. Now I'll go further though. All that happened with shots 1, 2, and 3 was ulcerative colitis. It was so bad. We got her under control. All through 2015, she healed and we got her back. And then this, and a whole bunch of new stuff.
Counsel, if you still want to keep your 5 minutes for rebuttal, then we'll have to stop it
Okay.
there. You can absolutely use it up now, but if you want to keep
I
it,
want
then
to
I'll have
save
to
it.
interrupt you. I'm not trying to be rude.
No, I understand.
It's your option that we'll give to you.
I
Okay,
will save my 5 minutes. Thank you.
thank you.
May it please the court. Good afternoon, your honors. Again, I'm Adam Davis with Wagstaff and Cartmel, representing all of the defendants in this case. The district court was correct on all issues, but as Judge Hurst suggested, the clearest path to affirming is on causation. And so that is where I'm going to focus my argument first. And of course, it is black letter law that the plaintiff must have evidentiary support for all elements of her claims. And I don't think it's in dispute that causation, proximate causation, is a necessary element of any medical negligence claim, no matter how it is framed. And there is simply no evidence in the summary judgment record showing that the defendant's administration of Gardasil in 2016 caused any harm to the plaintiff. And certainly I'm sympathetic, as your honors expressed, to a mother who's trying to protect a child, but ultimately this is a straightforward application of this court's rules. The question for you is whether the district court erred, and it's simply not error for the district court to rule on a summary judgment record that just did not have the necessary facts. As the district court correctly ruled, this is a medical negligence case, and therefore causation must be shown through an expert witness. And again, I think it's undisputed that there was no expert designation here. We gave her extra time. The court gave her extra time. The initial deadline was March 1st. The trial judge commented at the May 12th summary judgment hearing, so that's about 2.5 months, that there still was no expert designated. And I think importantly, also no request for additional time, whether that was to designate a retained expert, whether that was to list a non-retained expert, as was suggested during her argument. Certainly, one of the treating physicians would be a non-retained expert, which also has to be disclosed under 6226B. So none of that happens. That just leaves us to the question as to whether this is one of the very rare cases where all elements can be shown without any expert testimony. And to start that inquiry, especially as to causation, I think it's important to consider what is in the summary judgment record, not what may have happened, but what is actually in the record. We laid out facts properly supported under Rule 141, and those were all undisputed. The plaintiff did not respond with any additional facts. In theory, I could actually argue that there's no evidence of a vaccine being administered because there's nothing properly in the summary. I'm not going to do that. We admit that there were 3 Gardasil vaccines in 2014 and 3 more in 2016. But what I will argue, because it's important, is that there is no evidence as to the condition of the plaintiff. And there is simply no way for her to establish medical causation without establishing, with summary judgment evidence, what happened to the plaintiff. Because ultimately, what she is saying by invoking the common knowledge exception is, if we took this to a jury with the evidence at summary judgment, that the jury would be able to take this evidence and infer the negligence and the causation from the evidence. And the only evidence that was actually in the summary judgment briefing, there were 2 links to the CDC that talk generally about the schedule for Gardasil vaccinations. And then there was a reference to a statement of counsel, which does establish, again, statements of counsel are not really evidence, but it establishes that these vaccines happened. And they happened in the way that my opposing counsel laid it out in her argument. All that we agree with. So that still leaves the question of whether giving 3 doses of an updated Gardasil vaccine in 2016 would necessarily, absolutely cause, after having given 3 doses 2 years earlier, whether that is absolutely necessarily something that anybody would know would cause harm to somebody who received that. And that's simply not the case under Kansas law.
Mr. Davis,
yeah.
Can I, there's an allusion to a non-medical negligence argument regarding sort of a per se violation of negligence argument, I guess, about the loss of the medical records. So can you talk to me a little bit about, I understand the first vaccine was administered with your client, and then the next 2, would you have records of those? And where are the records?
Honestly, I can't answer that question because it's not in the court's record. And to be quite honest, when I take on a case on appeal, I don't want to know anything that's not in the record because I want to be on parity with everyone who's in front of me on this bench. And I think it's black letter law that you can only decide the case based on the record. So I have not looked at any medical records in this case because none of them are in the summary judgment record. So
you do admit, though, that you did admit that she received 3 vaccines and then 3 more.
Yes, that's right.
And that is based on affirmations of counsel.
That, I mean, again, technically it's not evidence, but I am not denying that she received 3 vaccines and that what our counsel said it was actually a motion to dismiss hearing is exactly the same as what counsel here has represented today. That it was 1 in our office in 2014, 2 at K-State, and then 3 more in 2016 with a different version, but still Gardasil, still an HPV vaccine, but updated with much broader coverage.
Okay, and then so do you admit then that your clients did lose evidence of her vaccination records?
I do not admit that. I honestly do not know whether that is true or not, but for your honor's purposes, the only thing that is important to know is that there is no evidence of that in the summary judgment record. And so therefore it could not be, or it should not under this court's rules be the basis of any decision overturning the summary judgment, because the court is bound by the same thing. The court also, the trial court was bound by the same thing. It could only make the decision based on the records that were in front of it. And just since that has come up, I do have a couple of cases. I'm sorry, I'd have to dig through my notes to find them, but yeah, so State v. Bryant, that's 285 Can 970 at pages 981 to 82. State v. Valadrez, probably pronounced that wrong, sorry, 288 Can 671 at page 686. And Edwards v. Anderson Engineering, Inc., 284 Can 892 at page 895, 2007. All of those make the same point, that you are limited to what is in the case record. I don't think that's really in dispute, but since you're asking me questions that are outside the record.
I asked because you said that you do admit that she received so I'm trying to clarify.
Yeah, I'm sorry, Your Honor.
Where that was coming from, if there is a loss of records, because we don't have records that she received 6.
Okay, yeah, and there is nothing in the summary judgment record that shows her receiving 6. The reason I acknowledge that, I mean, partially, honestly, is just to move the discussion forward, but
Sure.
Our counsel, Ms. Beckman, did acknowledge during the summary judgment, I'm sorry, during the motion to dismiss hearing, that those 6 vaccines were given. And opposing counsel did, in their summary judgment briefing, cite to that statement. So I think, even though it would be against the technicalities, I think it's fair for you to consider that. But I do not think it would be fair to consider anything about lost medical records, because it's not in there anywhere.
We do appreciate when counsel admits facts and gets along and moves the discussion along. So thank you for your candor in that respect too.
Okay, thank you. You're welcome. Sorry. Just want to get back to see where I was here. And so, I was just on the question of whether this whether this common knowledge exception applies. And I think it's interesting, if you look at the cases, they are situations that are just so obvious that you wouldn't require any medical knowledge to determine them. I thought it was interesting that there is actually a split of authority in the Kansas courts. One case is called Perkins, one case is called McKnight, on the issue of whether falling off of an X-ray table is per se negligence that you do or don't need an expert for. One said yes, one said no, I don't know why. But what that tells me is that that's where the line is. The line is somewhere close to falling off of an X-ray table. And we are so far past that. And as Your Honor said, especially on the issue of causation, on the question of giving somebody a vaccine and what does that do to them? Does that harm them? Does that help them? We simply need medical testimony to determine that. And then, as I mentioned, the need is exponentially greater when we simply don't have any medical records that show what actually happened with the plaintiff. But even if we did, that would still be a medical case, because for proximate causation, you would actually have to show that it wasn't just not just but for the vaccine injured her, but it was because it was a second dose. They're actually alleging the first dose hurt them. So for proximate causation, you would have to show that the negligence is supposedly giving the second series, so that there was something more from if you're following what I'm saying, there's something more from the second series. Now, none of this is in there. The but for isn't in there. The proximate isn't in there, but I'm just trying to explain why this case is the medical causation testimony was particularly necessary. I'll briefly hit a couple other points, even though they weren't brought up in the argument, just since my one chance. Discovery hadn't closed. That's one of the arguments that they make. It's technically true. There was some time left in the general discovery period, but the expert deadline had passed. And there's also a procedure in the summary judgment rules, 6256F, that if you have a summary judgment motion against you and you say you need more time because I need to depose this person or find these records or whatever it is, that you implement that procedure, you tell the judge, I need more time and here's why, and none of that happened here. And the question of whether the judge properly ruled on the record before him, as opposed to granting more time for discovery, is an abuse of discretion standard under Kansas law. And if you want to cite for that, it's Troutman v. Curtis, 286 Can 452 in 2008. So it's an abuse of discretion standard. So I don't know how the court could conclude that a judge abused discretion for not granting extra time when no extra time was sought. So the fact that discovery technically hadn't closed really doesn't matter. And especially again, when expert testimony was necessary and that deadline was closed. There was an argument briefly mentioned during opposing counsel's period that they might have at trial, they might have been able to depose or not to depose, to examine certain witnesses and elicit certain testimony. Crooks v. Green is right on point from this court in 1987. You cannot avoid summary judgment based on the hypothetical theory of what might come down the line. If you could, there would be no point to the summary judgment practice. Anybody could always say, I might get a certain testimony in the future. And then the last thing I'll briefly address, there was an argument in the brief about us supposedly misrepresenting an argument about whether it was intentional or whether it was negligent. I'm not taking any position on that. All I would say is, again, two things. First of all, this is based on a medical record that's not in evidence. So your court has no ability to assess the veracity of that argument. And then the second point is, again, getting back to causation, the argument still says nothing about the medical causation issue. As to standard of care, it's essentially the same argument. I mean, we're certainly not conceding the standard of care. I'm just saying causation is where it's clearest, but you would need an expert on the standard of care as well. Again, the record is pretty sparse as to what happened. And so if the question was before you, if you asked somebody at the grocery store, you got one series of this vaccine in 2014, you got a new updated series in 2016. Is that a breach of the standard of care? I have no idea. I assume your honors don't have any idea. It's the kind of thing that we need a medical expert to tell us. So again, the analysis would be the same on that point as well. And I'll conclude my argument with that unless your honors have questions.
Any other questions? No, thank you.
All right, thank you.
Reserve more so that I would not be emotional, because now I'm not going to be emotional. Okay, so
Hold on, let me get your time going. All
Okay.
right, sorry, I had to get back. All right, 5 minutes.
okay, very good.
Here we go.
Controverted facts. Their position alone showed there were controverted facts, and that alone should have made it improper for summary judgment. The controverted facts should have been sent to the jury as far as they're saying, oh, it was medical judgment. No, it wasn't. It was absolute error. That's a controverted fact, and it's important because if in fact a doctor acknowledges breach in the standard of care, then there is case law that there is no medical expert necessary. Now, whether or not that's why they took that position, I don't know. But to me, that alone, whether or not it was misleading, whether or not it was ignorance, it represented a controverted fact, and it alone to me meant there was no basis for the summary judgment. They talk about Green a lot. Green's a very different case. I can distinguish almost any case I can distinguish with the facts because this case is so unique. Almost every case that they reference where they say you have to have a medical expert, you've got people that are elderly, that are frail, that have comorbidities, that have had surgeries, all these things are going on. Yeah, they do. They need medical experts. The cases that don't need medical experts are much more complex than ours. They're cases where people have fallen off an x-ray table. They have had other, perhaps even surgeries. There's nothing as simple as a healthy young woman who after shots 4, 5, and 6 gets many more ailments. And they have her medical records. I signed a release. My daughter signed a release right off the front. All of her medical records they can have access to. So if they don't have the records, that's on them, not us, but the proof is out there. Regarding the informed consent, right? She had no informed consent. What they had her sign, what they showed us was something that was dated 2006. That was when the publication came out. That's a violation of federal law. We've asked for the lot numbers of the vaccines because I wanted to know what was in her, because different vaccines have different ingredients in them. They can't find all of them. They haven't given me all the lot numbers. As far as the records being lost, I mean, to me, there are multiple claims that weren't even ruled on. All that was ruled on was Dr. Ballou negligent, and does she need a medical expert? But they didn't even talk about the informed consent claim. They didn't talk about the lost records. Lost records is proximate cause, right? Anybody's going to know if you lose your patient's vaccine records and your doctor is the one who's going to order more vaccines, you know that that's going to be the end result. You lose the records in your own office, and your doctor is going to reference those records when your patients come in and they see there's no vaccines. It's proximate cause, right? But I mean, it's the natural sequence of events on what's going to happen. We're going to end up with this injury.
Ms. Illig, one of the things we've talked about here are controverted facts. I apologize, I'm going to take a minute of your time. The court granted the defendant's summary judgment. They wrote a summary judgment where they put forth facts that they believe are uncontroverted that allow them to win their case. And then you responded to their summary judgment, but you did not controvert their facts.
I did not respond as I should have. I should have numbered my paragraphs, and I have since seen that. So that was my error.
Well, and when I look at it though, I mean, they have a lot of facts set forth. And even if I look through your summary judgment, giving it all due sort of looking at it with an eye toward less formality, I do not see that their facts are addressed. So then the rule of law is that you have admitted everything that they said. And so this court, do you understand, is bound by that.
I understand the statement that you made. My argument would be that, and I think part of what's made this so convoluted, it's a simple case. I mean, she messed up. And so what's made it so convoluted? We had another judge who told them, I'm not going to dismiss this. And I think that, and all that, all that's out there, it's all the transcripts. And so much of had already been addressed in front of the other judge. So my error for not responding in a way that perhaps was protocol, but what I believe I said still supports our position. And so to me, it would be odd if they write something that's in direct conflict with everything that's in we had 3 hearings prior to that. But then they write something, and if I don't write back and say, no, I disagree, suddenly everything that's happened's out the door. Well, that seems like that's not the way justice was designed to work.
I understand. We do have formalities in the law, and this court, I'm sure you understand, is bound by what has happened prior to what comes to us. So we don't get to redecide a case. We have to address just the very small thing before us because we don't have the whole case. And so I want you to understand that that is the position that we are in.
So all the transcripts, the hearings, the prior judges, none of that has any bearing on the way you rule.
We rule based on the record before us and what is before, and the court's decision before us. And the court's decision before us is granting their summary judgment.
And so if the summary judgment is based on, again, my hypothetical, it's a controverted fact, not my hypothetical, my reality, a controverted fact. I mean, that's where I'm confused, I guess, because I continue to hold my position. I never changed my position.
I understand. And I'm just sort of letting you informing you of the procedurally where we are is we have their summary judgment and your summary judgment response and the court's decision. And that is the issue before this court.
Well, and I appreciate you clarifying that, but the claim, I mean, and that's it, the claim was factually supported. And so I guess that's where I'm confused.
I understand. I'm sorry that I can't be more clear, but I did want to try to help you understand procedurally sort of where we are and how this court is limited. We are not able to take up the entire case.
Right. And I understand that, but when you have, I mean, every transcript from every hearing is on the record. So everything that happened and the admissions and acknowledgements that were made, that's all out there. And the fact that my daughter, I mean, the informed consent, I mean, that wasn't acknowledged. That wasn't anything that was saying, oh, I agree. I admit that because I didn't number a paragraph, right? I mean, that wasn't out there. So the informed consent and the records, none of that's been addressed.
We appreciate your position. You are out of your rebuttal time.
Okay.
I can give you, 30 seconds to wrap up if you'd like.
No, I think that it's very important because I do believe the justice system was designed in a way to protect the people like my daughter. And something is terribly wrong if people like my daughter can't get the justice they deserve. It's a disservice to the community because this means she gets to continue doing this. I mean, something needs to change, right? If because it says medical expert, but yet the purpose of medical expert is to get the information the jury needs to be able to make the decision that's educated. Because somebody might be a lay witness but give the same testimony because of semantics, somebody doesn't get justice, that's a problem. And hopefully what I read when I came in your walls proves true. Thank you.
Thank you both, counsel. We'll take this matter under advisement. We appreciate your arguments today and your briefing, and we'll get a decision as soon as we can.